I think I've found one of the best examples yet of the abuse of privacy and the occasional collision between privacy and freedom of expression. I'm going to be talking about an American case from the perspective of a Canadian privacy lawyer. Though it's American, it's too good to pass up. I'll give you my opinions and try to be educational about how something like this would be treated in Canada. Most of the civil claims asserted are similar, if not the same in Canada, though our freedom of expression framework is a bit different here. This case is completely bonkers. It represents an attempt to use or abuse privacy laws for the purpose of suppressing speech that is directly focused at legitimate criticism of state action. It's also a great example of the Streisand effect, where the police officers involved who are the plaintiffs in this lawsuit have brought much more attention to themselves by making these spurious claims. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. Some time ago, I was on Twitter and saw someone link to a video. It was by a musician named Afroman called "Will You Help Me Repair My Door?" At the time, I thought it was hilarious. The police, with guns drawn, raided his house on a search warrant, broke down his door, generally tore the place apart, and admired the lemon cake in his kitchen. Afroman had security cameras all over the place that recorded much of the goings-on. They found nothing of interest, took a bundle of cash, and refused to fix the broken door. Being a musician with a bent for social commentary, Afroman wrote 3 songs about it, took the video of the raid and turned it into a music video. The videos are linked below. You should watch them. They're a great example of social commentary via music and highlight the overreach of the police in situations like this. I saw that particular video, liked it, and thought that was it. Now, there are 3 videos that have come out of this incident. The first is called "Will You Help Me Repair My Door?", which is referring to the fact that the police broke down his door and then refused to fix it. The second video is called "Lemon Pound Cake", which is about the police officer caught on surveillance camera scoping out a lemon pound cake on the kitchen table. The third video is called "Why Are You Disconnecting My Video Camera?", about the fact that police made an effort to disconnect Afroman's surveillance system while they were rummaging all through his stuff. They're all great, and all 3 are linked below. Then I saw reports, including this video from the YouTube channel of Leto's Law, that Afroman is being sued by the police for invasion of their privacy. This is completely bonkers. I wanted to know more. Well, I managed to get my hands on the civil complaint filed in the Court of Common Pleas for Adams, Ohio. I'm not an American lawyer, and I don't know the details of the Ohio statute that's relied upon for one of the claims. But many of the torts pled exist in Canada and are worth talking about from the perspective of a Canadian privacy lawyer. Or at least I think so. I want to talk about it. So let's start at the beginning. Sean Cooley, Justin Cooley, Michael Estep, Sean Grooms, Brian Newlands, Lisa Phillips, and Randolph Walter Jr. are the plaintiffs. They're all employees of the Adams County Sheriff Department in Ohio. Walters and Estep are sergeants. Newland is a detective sergeant. The rest of them are deputies. All of these supposed public servants seem to think that they have an expectation of privacy when they're in someone else's house performing their public service jobs. I actually think that's laughable. But here's the damage being alleged. They say, quote, "As a result of the defendant's actions, plaintiffs have been subjected to ridicule, even in the further performance of their official duties by members of the public who have seen some of the defendant's above-mentioned postings. In some instances, it has made it more difficult and even more dangerous for plaintiffs to carry out their official duties because of comments made and attitudes expressed towards them by members of the public." It goes on to say, as a further result of defendants' actions, plaintiffs have been subjected to threats, including death threats, by anonymous members of the public who have seen some of the defendants' above-described postings. Unquote. That initially sounds harsh, but it's hard to be that sympathetic to a situation where you're being subjected to ridicule for a largely accurate depiction of what you did. Maybe it was really ridicule-worthy? So the first claim is rooted in a very specific Ohio law. And again, I note that I'm not an Ohio lawyer, though I can read a statute. The complaint reads, quote, "Defendants use the personas of the plaintiffs for commercial purposes during plaintiffs' lifetimes without their authorizations to do so. The personas of the plaintiffs were not used by defendants in connection with any news, public affairs, sports broadcast, or political campaign, and their unauthorized use of plaintiffs' personas for commercial purposes was not justified or excused." Unquote. That claim is rooted in section 2741.02 of the Ohio Revised Code. Quote, Using individuals' persona for commercial purpose without authorization, unquote, is the title. It specifically says, except as otherwise provided in this section, a person shall not use any aspect of an individual's persona for a commercial purpose. It then goes on and includes some clarifying provisions. For example, paragraph D, for purposes of this section, 1. The use of an aspect of an individual's persona in connection with any news, public affairs, sports, broadcast, or account does not constitute a use for which consent is required under Division A of this section. You'll recall that in paragraph 34 of the claim, the plaintiff said that the defendant's use was not for, quote, news, public affairs, sports broadcast, or political campaign, unquote. So they're trying to get themselves out of the effect of subsection D1. Interesting, but there's no citation in the plaintiff's statement of claim to the fact that a little further down the statute book, you'll find section 2741.09, which seems to absolutely bar their claim. It says, quote, this chapter does not apply to any of the following: a literary work, dramatic work, fictional work, historical work, audiovisual work, or musical work, regardless of the media in which the work appears or is transmitted, other than an advertisement or commercial announcement not exempt under Division A1D of this section, or the material that has political or newsworthy value, or original works of fine art, unquote. It also excludes reporting on an event of public interest and excludes First Amendment protected expression as long as it does not suggest endorsement by the plaintiff. Now, I would think that these music videos are dramatic works, audiovisual works, musical works, and material that has political value. It really looks to me like this first claim is doomed to fail. The next claim is called appropriation of name or likeness, which says, quote, one who appropriates to his own use or benefit the name or likeness of another is subject to liability to the other for invasion of his privacy, unquote. It is essentially the common law version of the Ohio Code claim, and I think it would be doomed to fail on the same basis. In Canada, torts, kind of meaning private claims, must be interpreted in a manner that take into account freedom of expression. And freedom of expression would include the right of a musician and songwriter to express him or herself. It would be different if a defendant were to take an image from the video and use it to suggest a commercial endorsement. For example, if you were a cake store and created an ad for your lemon pound cake and included this image of Deputy Sean Cooley to suggest that Deputy Cooley was endorsing your lemon pound cake, that may qualify and be defensible and actionable, even in spite of the charter. Now, Afroman isn't selling pound cakes here, though. To use a Canadian example, Ottawa Police Constable Daniel Monstion could never successfully sue the Canadian Broadcasting Corporation for using this image of him wearing what are called assault gloves. But if a company that makes assault gloves were to include this picture in their advertising, that would be a commercial appropriation of his image, and he could sue. He'd probably be successful. Now, any interpretation of the tort of appropriation of personality would have to take into account charter-protected speech that is at the core of the values that animate the freedom of expression rights in Section 2B. The courts have said these are premised upon fundamental principles and value that promote the search for and attainment of truth through the open exchange of ideas, participation in social and political decision-making, opportunity for individual self-fulfillment through expression, fostering self-actualization, and thus directly engaging individual human dignity. Music, and particularly music that is biographical, hits the bullseye for this, and the appropriation tort would have to be calibrated to steer clear of this. In the claim, Count 3 alleges invasion of privacy, false light publicity. What this requires is one who gives publicity to a matter concerning another that places the other before the public in a false light is subject to liability to the other for invasion of his privacy if the false light in which the other was placed would be highly offensive to a reasonable person and the actor had knowledge of or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the other would be placed. Notably, the statement of claim does not say how the plaintiffs were placed in a false light. While the video is cut creatively, it doesn't appear to have been altered. And at least in Canada, I think you'd have to include in your statement of claim something more than there's a false light. You'd have to plead what the false light is. Does it make the cops look incompetent? Does it make them look over-aggressive? Does it make them look like they're fans of lemon pound cake? Did they get the warrant for the sole purpose of admiring said lemon pound cake? Are they trying to make work for local carpenters? Does it make them look like they're trying to cover up what they're doing by disabling his security cameras? At least in Canada, you'd have to include what is the false impression given by the videos. I also don't think the broadcast of this surveillance video from Afroman's home or their inclusion in the music videos would be highly offensive to a reasonable person, and that's required for the tort. As with the previous claim, the claim in Canada would have to be read in light of the Charter right of freedom of expression, and I think it would fail. The fourth count listed in the claim is publicity given to private life, and what this tort says is, one who gives publicity to a matter concerning the private life of another is subject to liability to the other for invasion of privacy, if the matter publicized is of a kind that would be highly offensive to a reasonable person and is not of legitimate concern to the public. Well, let's start with the fact that the videos are of cops doing their jobs in the home of the defendant, and that has nothing to do with their private lives. They're carrying out a public role in a place where they have no expectation of privacy. This claim should fail on that basis alone, and the fact that it's not highly offensive to a reasonable person. But importantly, this tort also includes and is not of legitimate concern to the public. I would have to say that how the police do their jobs, particularly in the context of a search of a private home, is of legitimate concern to the public. Count 5 is largely bundling them all together and looking to get an injunction to get Afroman to stop hurting the plaintiff's feelings by airing these videos, selling merchandise, etc. They're also asking for $25,000 damages for each of the counts, along with punitive damages, legal fees, etc. Now, taken all together, I think this is a bonkers claim that will likely be thrown out on a summary judgment motion. But worse, I think it's an abusive use of the legal system and the use of privacy claims to suppress legitimate speech that is critical of police action. I have no sympathy for the officers who are now facing more scrutiny because they brought this bonkers lawsuit. I have a video on my channel on the rules related to recording the police in Canada in public places. I should add that you absolutely have the right to record the police in your own home and to use that recording to publicize their actions. Now, I don't know what the court rules are in Ohio, but I hope that Afroman gets his thrown out and gets his costs. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics for me to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.